How does a Texas divorce work? It's really a lot of information to try to put in one video. I don't know how many total videos there will be for this series, but I think there's going to have to be at least 4, maybe 5. In the last video, we talked about the procedural aspects of a Texas divorce, but in this video, we're going to talk about the substantive areas. You can have as few as 2 separate substantive areas within your divorce, or you can have as many as 7. So every divorce, no matter how simple, is going to have at least those first 2. And those first 2 are the status. The status of the marriage is separate and distinct from other decisions that are made in the case. And the second big one is property division. So you're always going to have status and property division. You may say, well, we don't have any property. We don't have much property, or all the property's mine. But there's still the property division section of the case when you're looking at it theoretically. So the different sections that you can have of the case are the status and the property division. And then after that, you can have spousal maintenance that can come up and can be an issue in a case. Then you can have, if you have children, you can have child support, and then you can have child custody. Then you can have some miscellaneous other provisions, things like tax provisions and stuff like that. And then the last thing that a lot of people are not aware of is the fact that you can actually include lawsuits within your case against your spouse. So if your spouse has assaulted you during the marriage, I think slander is one that could be brought very easily in a lot of divorce cases. So whether you should bring those is a question for another day, and we're not going to cover all that in this video. As I had said, we're going to cover 2 or 3 sections in this video, and I think the ones we'll cover in this are the status, the property division, and the spousal maintenance. So the status is really, in one sense, the simplest part of the case that gets decided, but in another sense, it's the most important, because it's the decision of, is the marriage going to remain intact? You know, back in the olden days when they actually had defenses to divorces, and there wasn't the concept of no-fault divorce, there wasn't the concept of just being able to get divorced just because one side or the other wanted to. The status came up, and you had to actually plead a ground. You had to actually point to something and say, hey, court, I want to dissolve this marriage based on this particular ground. And so all of those grounds still exist. The 2 that you see most often used are adultery and abuse of some type. So cruelty is what they call that. It can be physical cruelty or mental cruelty. But it's really some form of abuse is what's being alleged there. But those other fault grounds still exist. The abandonment fault ground, you can have a ground based on mental illness, things like that. The reason you don't see those used anymore is because they don't really get you anything, and they don't really apply except in some very technical circumstances. And so it's just easier for people to use what everybody calls the no-fault ground. So what is the no-fault ground? Well, that's the one that is actually technically referred to as insupportability. And so what you are saying to the court is, hey, court, my marriage has become insupportable because of discord or conflict of personalities that destroys the legitimate ends of the marriage, and there's no reasonable hope of reconciliation. If you make that allegation to the court, or if your spouse does, or if both of you do, I can guarantee you that if you want the divorce, you're going to get the divorce in the state of Texas. There is a provision in the family code that talks about getting counseling and the court ordering counseling, but in 35-ish years of doing this, I've never seen that happen. Early in my career, because I'm against divorce, because I don't do this because I like divorces, I had some cases in which I wanted the court to order counseling. And what I was told by the judges, at least back in those days, was, yeah, that provision's in the family code, but we really don't ever follow that. So it's there, and if you want to ask for it, you can, but whether or not you'll get that is really up to the judge. So it's almost guaranteed that if one side or the other wants a divorce, all they have to do is plead that insupportability ground. and there's no defense to that. You can't come in. They don't recognize that you're able to come in and argue about that. But just because one side or the other, or both sides, can plead the insupportability ground does not mean that fault grounds cannot be pled. So either side is still entitled to allege fault grounds. Either side is entitled to allege, if the facts support it, that the other person has committed adultery during the marriage. And what that means is from the time the marriage starts until the time the marriage terminates. So that includes while the parties are in a divorce, while the divorce is pending, while they are separated, all of that can still be included in an adultery allegation. Whether or not it gets you anything in the case is another matter that we'll talk about here in just a minute. And then there's also the cruelty grounds. Like I said, if a spouse, one spouse or the other, or potentially both, are victims of family violence, then a cruelty ground could be alleged, physical cruelty. There can also be the emotional cruelty, mental cruelty that can be alleged in a case. So those can be alleged, and the court can grant the divorce based on any of those that it finds are supported by the evidence. Just because you plead those, just because you prove those, does not mean that the court is going to grant the divorce on that ground. I can remember distinctly a case that I was involved in several years ago where my client actually on the witness stand admitted to the adultery that had been alleged, and the court understood that, took that evidence in, and then still granted the divorce on the insupportability ground. Sometimes they're worried about kids looking in the records and seeing things about their parents, and so they don't want that in a permanent record. So just because you pleaded it and even prove it doesn't mean that that's what the court is going to grant the divorce on. And I will say it's virtually unheard of for somebody to agree to a divorce. Although most divorces end up being settled, it's virtually unheard of that somebody is going to agree to a divorce based on a fault ground against them, based on adultery, based on cruelty. Very few people will put their names on a document that says, oh yeah, I admit that I was cruel to you. I admit that I committed family violence against you, or whatever the other allegations are. So in and of itself, the status simply has to do with the court dissolving the marriage, which obviously has significant impact because it changes the whole complexion of property at that point. And we'll talk about that here in just a minute. When the court grants that divorce on one of those grounds, whether it's insupportability or one of the others, that is simply the reason for the divorce. In and of itself, it doesn't have anything to do with who is getting what in the case. All of that gets decided in that next part of the case, the property division portion of the case. And property division is interesting because there's a massive amount of misunderstanding. I've heard people for years talk about how they are happy to give their spouse X percentage of it. I'll be happy to give my wife her half. I'll be happy to give my husband his half. Well, there is no half when it comes to community property. The way property works when you're married is somewhat complex and somewhat simple. So to try to take it from the simple to the more complex, before you are married, you cannot own community property. It's a legal impossibility because there is no community. So people sometimes think, well, yeah, but we bought our house right before we got married, and then we got married the next week. So that's our community property. Or we bought this car together, and then we got married a month later or 6 months later or whatever it is. So that's community property. No, it's not. If you purchase the property prior to marriage, it cannot be community property. It can be owned jointly. So it may be that you each own a 50% interest in the whole, but it is not community property. And as I said a minute ago, a 50-50 ownership split of a particular item, whether it's something very high priced like land, a couple thousand acres of land, or whether it's a dinette set, 50-50 ownership by being joint tenants is a very different concept than owning it as community property. So once the marriage happens, the community estate gets created, and that's what gets divided in divorce. So the community estate gets created once the marriage happens, and it lasts all the way until the marriage ends, theoretically. Now, potentially, you can change that with a postmarital agreement. And certainly what I'm talking about now is the rules still apply, but you can change a lot of this, if not all of this, with a premarital agreement, but that's not the topic for the video today. So the community estate, the community property, is what gets divided in a divorce. It also gets divided in probate matters. So your marriage is going to end. Some people get a little startled when I tell them that, but all marriages end because it's either going to end by divorce or death. Unless you're planning on living forever, your marriage is going to end. The difference is that in probate, when one or the other of you passes away, there's a rule called as DWAP, stands for Death Works a Partition. And what that means is the instant one person passes away, the community estate is chopped in half. So at that point, the decedent's estate owns their half, and the surviving spouse owns the other half. And there is no debate about it. The probate court doesn't have jurisdiction. Jurisdiction means power, and they don't have the power to say, well, I don't like that division because this person, the surviving spouse, deserves more than that or whatever. It just can't happen that way. But divorce, it can. In divorce, it's all up for grabs. In divorce, conceptually speaking, when one or the other spouses files for the divorce, you are taking the entire community estate and basically giving it to the judge and saying, okay, judge, now this is yours. Now you give us back the portion of it that you think we're entitled to. In case, you'd have to realize that the court is obligated to divide 100% of it, meaning the court can't say, okay, well, I'm going to keep 20% for myself, and then I'll give you each your portion of the rest of it. That's not the way it works. I don't mean to say that. But conceptually, it's like you're taking your property and giving it to the judge and then making your argument for the percentage that you think you should get. Now, if you go back to the procedural video, I think I talked in there about how most cases settle, and I'll probably say that over and over and over. If you settle your case, you can settle your case for whatever division you and your spouse can agree on. There's some misunderstanding about that. Sometimes what people think is that once the settlement is done, once the agreed decree is presented to the court, that the court looks at it to decide whether or not the court thinks it's a fair division. That's not what happens. Can a court reject an agreed decree? Yes, because I've seen it happen. So I know it can happen. I know it does happen, but it's very rare. Generally speaking, if you present an agreed decree to the court's going to sign off on it. So the court doesn't really make an independent analysis. The court is just looking at it from the standpoint of, do both sides agree to this? And if so, if they both agree, then I'm going to agree because I'm the judge and I'm ready to get this case over with. But if you don't settle, and I talked about that in the last video, I know, if you don't settle, you're going to trial. And if you go to trial, then it's up to the judge to divide the community estate. How the judge divides the community estate is what all the arguing's about. And so there is no rule that says the judge has to start out with a 50-50 division and then deviate from that. That is not in the law, although you can argue that that's what most courts do. Most courts come at it from the standpoint of, okay, let's assume we're going to start with an even division, meaning 50-50, and then let's look for reasons to deviate from there. So how much can they deviate? Well, they can deviate arguably as much as they want. For years, I said that a court could give one side or the other 100%, but it's not been until recent years that there's a Supreme Court decision out of the Texas Supreme Court that agrees with me and says, yes, that's correct. A court could give one side or the other under a certain extreme set of circumstances 100%. But is that going to happen for you? In all likelihood, no, not unless you've had a horrendous situation in your marriage. Generally speaking, you're looking at a division of around 50-50, maybe 55-45, maybe it would be 53-40. You can end up with a 60-40 split. Years ago, I had a judge that I would talk to quite frequently when I was a younger lawyer trying to learn how it all worked. And so I asked him on several occasions, and I said, how big of a split are you willing to do? And he was in one of the big cities here in Texas. And he used to tell me, well, 60-40 is about the limit. That's about as much of a split as I'm going to do. I asked him later in my career, later in his career on the bench, and he did admit and say that, well, 65-35 is something he would consider. I know one day I was over at court and I knew a judge over there that I could talk to off the record, just ask her opinion, ask the way things really work from the judge's perspective. And I asked her what the biggest division she had ordered was, and she was telling me about a case in which she had ordered an 80-20 split. So, and I said, well, what in the world could have caused that? She said, well, the person was hiding money and playing games and doing all kinds of improper things. And so I gave one spouse 80% and the other one 20% of the community estate. So let's roll back around to that for just a minute. It's the community estate that gets divided. It's not the separate estate. The court, theoretically, does not have any jurisdiction, does not have any power to divest either person of their separate estate. Now, there are some caveats to that, such that you can end up losing some of your separate estate because your separate estate can be used in the temporary phase of the case, like what we talked about in the first video, to pay temporary spousal support, which can include attorney's fees and things like that. So you can lose your separate estate that way. There's also a case somewhere out there in Texas where a court has said, oh yes, that house is the separate property of the husband because he owned it prior to the time husband and wife got married. But this couple was married and had children together. And so I'm going to order that as a part of the child support, the mom can live in the house and the primary residence of the children can be in that house. And so even though it's husband's separate property and he's not losing his property interest, he's losing effectively the use of it, at least until the child support obligation is passed. And so there can be some kind of hinky things like that. But generally speaking, your separate property is, for lack of a better word, safe. And it's the community property that gets divided. So how does the court decide how to divide that community property? Well, they look at a number of factors to decide what's fair. What the court is obligated to do is make what's called a just and right equitable division. A just and right equitable division. They don't like the word fair over at the courthouse or in family law mediations. You'll sometimes get mediators with cute little quips about how never use the word fair. But when you boil down just and right equitable division, that's what it means. It means fair. So the court is supposed to make a fair division of the property, but of course fair is in the eye of the beholder. So the judge is supposed to look at it, and generally speaking, they're going to look at three areas of reasons in which could cause them to change from a 50-50 to a disproportionate division, a division that's not even. And so, first of all, they look for those fault grounds, going back to what we said initially. If you plead fault grounds, a court can take those same facts that they're listening to, and a court potentially could say, okay, well, I understand that this spouse committed adultery. I'm going to grant the divorce on the no fault grounds, but I'm going to use, even if the court doesn't overtly say it, they can do it. I'm going to use those facts of the adultery, and I'm going to take those facts and use those to make a disproportionate division. So the fault grounds are one of the things that the court can look at, but that's not all they can look at. They can also look at economic. And you can make a good argument that that's probably most of the time what it is. Most of the time, the court is looking for those economic factors. What are the health of the parties? How healthy are the spouses? What is the age? What is the resume of each? What's their earning capacity? What's their income stream? What separate property do they have? What separate property does it look like they're going to possibly inherit? Do they have business opportunities? What's their education level? All of those sorts of things that play into the economics of it. So that's the second group of factors. And then the third group of factors involves children. And so we're not going to talk today about child support and child custody, but in addition to the court looking into child support issues, the court can also use what it knows it's going to do with respect to the child custody issues to create a disproportionate division radically in favor of the person who's going to have the greater burden of spending money on the kids, dealing with the kids, that sort of thing. So that's a lot to take in on property division. There's a whole lot more to it than that. There's the concept of waste. We talked about separate property and community property, but there's also the concept of not only are there those three things, so there's his separate, her separate, and the community, but within the community, there's the first spouse's community property that is subject to their sole control. There's the community property that the other spouse is entitled to solely control, and then there's community property that's subject to joint control. So a lot of that can play into a waste claim. So what is a waste claim? Well, theoretically, either side can spend the community property on whatever they want to, but there are limits to that. So what are the limits? Well, things that you would expect to be limits. If you're spending money on your paramour, if you're the husband in a marriage and you've got a girlfriend that you're seeing and spending money on, and basically what you're doing is you're taking community property from your marriage and then giving it in the form of gifts or taking trips or just any number of different things, entertainment with your girlfriend, that would be one form of waste. If you're taking the money and going to a topless bar and spending exorbitant amounts of money, that can be considered waste. Gambling and things like that, gambling can be waste. But if you go beyond a certain amount, then potentially that would be waste. So what happens with waste? Well, estate, you can have something called a reconstitution of the estate. It can get really, really complex. But I do want to go on to the third substantive area that I wanted to cover in this video, and that is spousal maintenance. Spousal maintenance is what we call basically alimony. What other states have that they call alimony, we call spousal maintenance in Texas. But they're not exactly the same thing. We have a different name for it because theoretically the basis for it is different. I looked up a case one time from another state, and in that state, their state Supreme Court said the purpose of alimony in this state is to equalize the living standards of the parties after the divorce. There is no such law in the state of Texas. That's not even close to the way our system is set up. When I got out of law school back in 1990, there was nothing other than contractual alimony. If one side or the other wanted to pay a person some money after the divorce in the form of alimony, they could. They could have a contract within the decree to pay the alimony amount. There could be certain tax consequences to all of that. But you still have that. You still can have contractual alimony, but the court can order something called spousal maintenance, but it is very regulated. Go back to the last video where we were talking about temporary orders. In temporary orders, it's the wild, wild west. There's virtually no rules to govern what a court can do when it comes to ordering temporary support in a case. But when it comes to spousal maintenance, there are all kinds of strict rules. So first of all, to even be in the conversation, you have to fit into one of three categories. Three, you can call them four categories because it's kind of a 3A and 3B. But first of all, you have to have either been married for a period of 10 years, or you have to have been a victim of family violence, spousal abuse, or you have to be disabled or be the caregiver to a child of the marriage that is disabled. What does that mean? It means if you're the wife and your child from a prior marriage has a disability, you can't get your current husband, when you're going through a divorce, to pay spousal maintenance based on the fact that you're having to care for this child with special needs. That's something that should have been addressed with the parent of that child, not with your current sense. So you've got to fit into one of those three categories. If you're not married over 10 years, if you're not the victim of family violence, if you're not disabled, if you don't have a special needs child of the marriage that you're caring for, then you're not even in the conversation. I don't care if you're married to the richest person in Texas. And if you've been the most faithful spouse in the world and the greatest spouse in the world and they want to divorce you, if you don't fit into one of those categories, you don't even get to ask the question of, hey, I'd like to have spousal maintenance. So if you fit in one of those categories, you still have to get over some other hurdles. So the most prominent of those is the idea of meeting your minimum reasonable needs. You have to show the court that you cannot meet your minimum reasonable needs when looking at everything you're going to have once the marriage is over with. So that means everything that you're going to get in that property division that we just talked about, and everything that you have by way of separate property, everything that you can earn with your earning potential and all. If the court looks at all of that, if you fit in one of those categories and the court looks at all of that and you still cannot meet your minimum reasonable needs, then you're at least in the conversation. Then you at least get to ask the court, hey, court, can you please order me spousal maintenance? And then the question becomes, how much will the court order? How much and for how long? That's what really needs to be decided at that point. Again, there are some real strict rules. It used to not exist at all. Then there was the first version of it, if you will, that was better than a sharp stick in the eye, but it wasn't the greatest deal in the world because the limits were really low and the period of time was really low. I think what it used to be is a maximum of $2,500 a month for a maximum of, I want to say it was like 36 months, something like that. So if you were married to some wealthy owner of a professional sports team, you were still limited to that little bitty amount of spousal maintenance, which was just kind of the last of the good deals if you really needed the money. But now they've increased it dramatically. It's still not fantastic if you're the one needing the money, but it's better than it was. So now what are the limits? Well, now it depends on which one of those areas you fit in. If you are getting it just based on length of marriage plus unable to meet your minimum reasonable needs, then the court is going to look and see how long the marriage has lasted. If it has lasted over 10 years but less than 20, then 5 years is the limit. If it has lasted over 20 but less than 30, 7 years is the limit. And if it has lasted over 30, 10 years is the limit. So that's the longest that the court can order it. But then that doesn't answer the question of how much can the court order. Well, there's an answer to that too that's real strict, and that is it's the lesser of 20% of the gross earnings, and I said that correctly. I don't mean net the way it works with child support. This is based on gross. So it's the lesser of 20% of the gross earnings of the person paying, or $5,000 a month. If you do all the math on that, what it tells you is if the person that is obligated to pay makes more than $25,000 a month, makes more than $300,000 a year gross, then they cap out at $5,000. So if you're married to, again, the richest person in Texas and they make money with the money truck backing up to their house every day and they make a screaming fortune, that's nice, but you're not going to get more than $5,000 a month, and you're only going to get it at a max for the limit that we talked about here just a minute ago. So I am not saying that if you fit into one of those categories, you get it for that long. So I am not saying, do not hear me as saying, if you are married for 22 years and your spouse makes $350,000 a year, and you're getting divorced and you can't meet your minimum reasonable needs, that you're going to get $5,000 a month for 7 years. That is not at all the way it works. The court is obligated to give the person that's getting the spousal maintenance as little as necessary for as short a period as necessary in order for them to then be able to meet their minimum reasonable needs, okay? So it is not a calculation that you can do and say, okay, here's how much I'm going to get. You're never going to know how much you're going to get. If there's any, we don't have one on our website, but if there's any law firms out there that have calculators to tell you what your spousal maintenance is, I can tell you the calculator can't be accurate because there's no way to know until you get there. One thing you do need to be aware of is if you fit in that third category, and if the spouse seeking the spousal maintenance is getting it based on a disability or based on taking care of a child with special needs, a child of the marriage with special needs, there is no limit, no time limit on that. So potentially that could last a lifetime. So what that means, if you piece it all together, is if you meet somebody in January and you get married to them in June, and on your honeymoon, a horrible event happens and they suffer catastrophic injuries and they are disabled, you can be paying spousal maintenance for that person for the rest of their life. So those are the first three substantive areas in a case that I wanted to talk about: the status, the property division, and the spousal maintenance consideration. Again, you're not going to have spousal maintenance consideration in a case unless somebody fits into one of those categories that we talked about. But every case is going to have to consider at least those first two. And then we'll talk about in the next video the child issues, the child support and the child custody, and how that all works. Thanks.